Things judges consider in child possession cases. That is our topic for today, part of the series Mediation Tips by Fran Brochstein. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcast. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, Mac Pierre-Louis, attorney, mediator, arbitrator, working throughout Florida and Texas.
And Natalia Łowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland, again from Texas today.
And I'm Fran Brochstein, an attorney and mediator in Texas.
All right, everyone. So the topic today is things judges consider in possession cases involving kids. Now, if there's going to be a topic that I guess keeps us lawyers up at night more, it's going to be one involving custody battles. Because child custody cases, maybe divorces or a close second. Child custody cases are generally known to be very antagonistic, and sometimes, as I've told my own clients, sometimes it boils down to which parent can make the other parent look worse, and you have a judge having to hear all of this, tearing each other down, in order to see how do I best protect children's best interests. Okay. Now, notice that the title is in child possession cases, not necessarily in custody cases or just visitation cases, because whether or not a parent has primary custody or not, both parents are going to have possession of their kid. Okay. So we find ourselves then debating before court how and when to restrict a parent's possession of a child, how and when to decide which parent should have primary conservatorship rights over that child, and how and when to even put certain injunctions or restrictions on what a parent can do when they have the child. So I'm going to let my colleagues, share along with, their experiences and things that they've seen judges consider. But I guess I'll start with this one thing, and that is judges consider very highly the opinions of third parties. Okay. There's a list of third parties we could talk about, but one of them will be, say, police officers. Okay. You have a custody battle that involves allegations of abuse. Well, maybe the police officers were called into a domestic disturbance issue, and that police officer is coming into court. Well, that judge is going to consider very, very highly what that cop has to say, because in my opinion, generally speaking, judges trust police officers. And so that's one example of somebody the court will consider as they weigh the evidence before them. Fran?
And in my experience, third parties that don't have a horse in the race, such as school teachers, medical providers, sometimes even grandparents, make very powerful witnesses. I saw a judge once listen to the grandmother testify, and basically she told him how the grass grew, that both parents had flaws. And he actually listened to her testimony more than anyone else we put on the witness stand.
And there are also other specialists and experts like psychologists, amicus amici, or any other surveyors that were actually involved in the family life, looking at how the things are operating. No matter how hard a parent might try, this objective eye view can be considered as an important evidence in the matter. So it is worthwhile putting an effort into really making a good impression.
Yeah, go ahead, Fran.
I always like to point out that even though we have laws, and the judges took an oath when they became a judge to follow the laws of their jurisdiction, that judges are human beings, and most of them have life experience. Many of them are grandparents. And so you have to sell it to the judge. And I often point out to people that if you're in a certain jurisdiction, you should talk to a lawyer that knows the judge and how the judge tends to rule in your area.
Yeah, I always say, I've said this to clients many, many times, that judges listen to grandparents, cops, and CPS. CPS meaning Child Protective Services, because those parties, they don't have a dog in the fight. All right, they generally are there to help protect children, and typically, usually, they're there with the child's best interest in mind. I'm thinking that people who are listening to this might, you know, think differently about their grandparents, because some grandparents obviously will take the side of one of the parents in a way that might not be in the kid's best interest. But I think generally speaking, grandparents are not the parents, so therefore they shouldn't have a motivation as to, which parent should be or should not be better. But if a grandparent gets in front of a court, definitely speaking, that's something that you gotta consider very, very highly. And that's a whole other conversation, by the way, that we might have just about grandparents in general.
And again, even though judges are those who shouldn't be biased, that should be objective, neutral, please remember that judges consider the way you look and the way you speak. And I tell my clients to be dressed in front of the judge as they would want to be perceived. So if you are a mother, dress like a person who you would trust as a reliable mother. So forget long nails, long eyelashes, and things like the court is not a date. You are going there because you are protecting your child. Look like a person protecting a child, not like someone who is going to impress the entire everybody who is around.
Yeah. Fred, anything else before I move on to the next
Well,
thing?
first, this topic could go on for hours because this is very, very complex situation. So we are just scratching the tip of the iceberg.
Especially, yeah. So one other thing that judges consider is going to be evidence, namely good evidence, or as we could say, damning evidence, right? Not just evidence of where one parent goes on a witness stand to testify about how good they are as a parent and bringing character witnesses to talk about how good they are as a mom, how good they are as a dad, and how bad the other person is. No, I'm talking about solid evidence for the court to weigh. For example, I've had cases where text messages come up, right? But judges don't want to sit there and read through thousands of your text messages. They want that one text message that's going to make a difference. The court will weigh that, and that may actually affect the outcome of your case. And you've seen text messages from everything from suicidal outcries to photographic evidence where somebody basically perjured themselves. Text messages can help a lot, but generally speaking, that along with all other evidence, the court's going to want to see things that are very serious in terms of evidence.
And I've always told clients that no case is won or lost on one particular bad parenting experience. The way to gain custody is to build a brick wall, and each bad parenting experience is a brick. And the reason many, many years ago when I litigated, I could get father's custody was because I made sure to build a very strong brick wall with tons of witnesses, tons of evidence. And I probably did overkill, but I tended to win because I would make sure I had everything in place. And many times I might work with a client for 6 months before we actually ever filed. So again, when my daughter was little, one time I poked her in the eye. I felt terrible. And she was mad because I poked her in the eye. But that's one bad parenting. That is not going to change custody. You have to have a series of very bad parenting, not just kind of yucky, but bad parenting.
Another thing that the judges would consider in the child possession cases would be the ability of a parent to co-parent. So the ability to be able to have a reasonable dialogue with the other parent and co-decide. This is something that cannot be stressed enough to say how important this is. In the modern times, the times of today, we oftentimes have both equally good parents. They are absolutely great in terms of taking kids or taking care of the children. They're absolutely good in terms of the, let us say, interpersonal relationship with the children. They have strong bonds. However, one will be hating the other parent, and the other one will be someone who will be trying to overcome the obstacles and try to reach out and see that this communication about the children with the other parent is something that changes everything. And make a guess who is going to be the primary custodian in such circumstances.
Yeah, one of the other things that a judge will consider in a child possession case would be the parent's work schedule. Okay, because a lot of times you're going to have a parent who's basically a stay-at-home parent, and that parent might be a better fit because, well, for primary custody, because they're with the child more, they have the ability to spend more time with the child and take child places and just play that role in a very, very powerful way. Now, maybe if the child goes to school, public school, then it may not matter as much. But if a parent has the opposite extreme and they're working, the evenings and they're not able to spend any time with the child, that's going to be a factor that a judge is going to definitely weigh. So the schedule is very important. I have had, for some reason, over the years, a lot of men, especially, who have had DuPont schedules where they have a unique type of work schedule, mainly in the engineering and oil companies, in my jurisdiction. But those calendars, those schedules can make it really hard for a man like that to have primary custody. Not that he can't, but it might create some confusion and some complexities where he's going to need a very, very custom and unique, calendar. But to have a standard possession order, that probably will not work real well because it might not go along.
And once again, mediation's always great because I had a gentleman that traveled all over the world, and he had a boy that really struggled with his math homework, and mommy could not do the math homework. So they did FaceTime every Monday, Tuesday, Wednesday, Thursday night at 7 p.m. Houston time. Dad and the kid did the kid's math homework. It worked for mommy. The kid was happy. Dad was happy. And with FaceTime and Zoom and all these new technologies coming out, there is no reason why a parent anywhere in the world cannot communicate on a regular basis with their child.
And I am being asked by many parents if the judges consider two other factors when deciding about custody. These factors are the earnings, so the actual salary, and the second factor, that are the conditions in which we live. For example, a mother is coming in and telling me, oh, he earns so much more than I do, and I just lost my job, and he has a bigger apartment with a view over the river and such a spacious place. I'm afraid I am going to lose my custody case. What do you think? Is it a factor to lose your custody battle?
So this is the thing about Natalia. She seems to be able to read my mind. I was actually going to say earlier, hey guys, wouldn't it be interesting for us to ask the question, what are things that judges don't consider? And actually, my thought was what you just said. I was going to say, generally speaking, in my opinion, judges most of the time aren't going to consider the size of your house and how much money you have. It, to some degree, yes, but generally, broadly, at whether or not you being wealthy should all of them automatically say, well, I can provide a better life for the child, therefore I should be the one to have the child living with me primarily. Probably not, in my experience. Every case is different, okay? But that's not a absolute win on one side. You can have a mansion, the other parent can have a more humble home, but at the end of the day, is what's in the child's best interest, who's going to provide the most safest and the most safe environment for the child, and how is this child going to be looked after and cared for. That is what matters, because you can't criminalize poverty in this country. And as long as that's the case, it's not going to make that much of a difference, in my opinion.
And I absolutely agree with that. I actually had that happen in a mediation. A multi-millionaire was bullying his ex-wife, and we did not settle at mediation. It went to the judge, and it was amazing. Everything I warned the man about has occurred, and because of his bad attitude and his bullying and his using money to try to intimidate mom, has actually backfired for him. It was basically his attitude was, it's my way or the highway, and the judge didn't buy it at all.
And this is the thing. Sometimes I even say to my clients that as long as it is not under the bridge that you are going to stay with your child, don't be afraid, because what you've been doing so far, what you've been providing so far, the bond you have with the child, the safety, anything that you can prove that was present in this child's life will be the main factor. If there is a shortage of money, there is an institution of the child support that can actually just bring some sort of balance into the child's life if someone is going to be the primary carer. However, on the other hand, when we think about child custody, we also think about shared custody. And this is something that a lot of parents become aware of during the custody battle at first. We've done a separate podcast on that, and I would like to refer you to that because there were some great remarks there. But please remember, your custody battle, if it's going to happen ever, starts today. Today is when you make the difference in the child's life. Today is when you show that you care. Today you show what sort of carer you are. Not in 2 years' time when you start your divorce battle or your custody battle.
Yeah, the last word I'll say to close out this show would be that mediation, again, is a way out of a very serious, very emotionally driven litigation, case. Judges would, in my opinion, prefer that you make up your own agreement that's going to be workable for both parents and good for the child and safe for the child. When a judge has to come in and make a decision, especially over two parents, where it's kind of hard because both parents are good parents. The parents just don't agree with each other. The parents just have their issues and personality wise and some conflicts, but they're safe parents, they're healthy parents, they're good, safe parents. In those instances, the court may scratch its head like, why are you coming to me? Can't you guys make it work and try to resolve the dispute? So remember, guys, mediation exists for this purpose. This is why we're all mediators and why we are always bringing this topic up whenever we're talking to you about family law. So you want to close this out?
Well, I was a divorce attorney, and I never took my ex back to court in 15 years. And I learned to mediate because he and I learned to negotiate. I always say a good divorce decree goes in your desk drawer and you never look at it again. The only people that tend to come to mediators, attorneys, or judges are unhappy people, and it's expensive to litigate. So whenever possible, learn to negotiate. It's a lot cheaper.
So for you to know, the last factor that the judges consider when deciding on the child possession case is the mediated settlement agreement. So be sure to have one before you appear in front of the judge.
Yeah, because if the judge sees the MSA, they won't need to do anything else. So unless, of course, the MSA is written in such a way that it's completely dangerous to a child, then in my jurisdiction, the judge does have a right to come in and substitute his or her own opinion for the parents. But most of the time, that's not going to happen, assuming that the parents are going to make safe decisions over their children. All right, guys, Mac Pierre-Louis signing off.
Natalia Oskachajka, such a pleasure to be in Texas to meet Mac and Fran in person. I can't even express how much I appreciate it and being welcome here. Thank you.
And I'm Fran Brochstein, and thank goodness she got some good weather in Texas.
All right, guys. Stay tuned to next time.